want your notebook? There's more.
Welcome to CN Live, Season 6, Episode 6, A Turning Tide, Assange and Netanyahu. I'm Joe Lauria, the editor-in-chief of Consortium News, reporting to you live from London, where on Monday, imprisoned WikiLeaks publisher Julian Assange won a rare victory in a British court in his battle against extradition to the United States. And on the very same day, an even rarer occurrence took place. The International Criminal Court's chief prosecutor asked for an arrest warrant for Israeli Prime Minister Benjamin Netanyahu over his conduct in Gaza. Also this week, Norway, Ireland, and Spain recognized the state of Palestine, which the United States and Israel arrogantly deny exists. Are these isolated events, or are they indicators that a tide is turning against supremely powerful interests that seemed for the longest time impossible to move? With us today to discuss these issues are former British diplomat Craig Murray, legal and political analyst Alexander Mercouris, and joining us for the first time on CN Live, the U.S. constitutional expert Chip Gibbons, and welcoming back to the program, journalist Chris Hedges. Thank you, all of you, for being with us. Craig, I'd like to talk to you first because you were inside the courtroom. You wrote another brilliant piece about it. And before I saw your article, we gave a title to the show called A Turning Tide. And then I went to look at your piece, and your headline is The Turning of the Tide. So clearly we're thinking along the same lines here. Now, although the High Court of England and Wales rejected most of the serious grounds of appeal sought by Assange, including the new evidence that the CIA spied on him and his lawyers also plotted to kidnap or kill him, it did in the end find the narrowest grounds upon which imprisoned WikiLeaks publisher could appeal the Home Office's extradition order to the U.S., where he faces up to 175 years in prison. Those grounds are that the U.S. was unable to assure that Assange could mount a free speech or First Amendment defense at trial in line with British extradition law. So, Craig, this rare court victory has apparently left you optimistic when I spoke to you, and I'd like you to tell me why you're optimistic about what happened on Monday.
I think, firstly, there's the narrow legal point itself, where the United States has really painted itself into a corner, and I don't see how they get out of it. The court has said that because of the risk that he would suffer discrimination by nationality, contrary to the Extradition Act itself, the United States must give an assurance that he would be allowed to make a freedom of speech defense under the First Amendment, which was not debarred by nationality. Now, it's very important to understand the court isn't insisting that the freedom of speech defense would override all other considerations. They're not insisting for an assurance in advance that freedom of speech would trump so-called national security considerations, for example. What they're insisting on is the narrow point that it won't be disallowed on the grounds of nationality. And the United States is in a bind because, firstly, their prosecutors, Attorney General Comberg, had already given testimony to the court by way of affidavit saying that the prosecution may make that point. That may be something the prosecution ask. Secondly, there's case law in the United States saying that a non-US citizen operating outside the US territorially cannot claim constitutional rights. And thirdly, the executive can't bind the court anyway. So even were the United States to say that the prosecution will not push that argument, they can't promise that the judge won't rule it out on grounds of nationality. So I don't see how they beat that point. I don't see how they beat it at the forthcoming hearing. So that's the technical point, if you like, on which the United States seems to be in a real bind over the assurance that's been asked. And the second point is this more general point, but I do think this represents a turning of the tide. I think it's against a background of much wider support for Julian Assange. I think it's against the background of his own Australian government having supported him, because if you don't have the support of your own government, frankly, you're on a very sticky wicket in the first place. It's not a sufficient condition for beating extradition, but it's pretty well a necessary one. And the judge said, Judge Sharp said, and it was very striking, given what is at stake here, when she was intervening or when she was making a ruling against effectively a motion by the prosecution, a request by the prosecution to limit the number of defense speeches, the judge said, given what is at stake here, I'm going to let them speak. And that seemed to be from the bench, a statement we haven't seen before, that they recognise the importance of the wider issues. So I think on the narrow point, the United States is in big trouble. And I think on the wider point, I think the tide has turned in the whole atmosphere around the case. So that's why I am optimistic at this stage.
Craig, why did it take 4 years for these two issues to really surface in this case? The death penalty issue, which was resolved, the Home Office never asked for that routine assurance from any country that's asking for someone from Britain to be extradited that has the death penalty. Britain has to ask them to give the assurance. That didn't happen for 4 years here. And it was the court that had to ask the United States to do that. Why did it take 4 years, as well as this First Amendment issue? It seems quite strange that this happened at the very last moment.
Why the Home Secretary hadn't asked because really for the Home Secretary to initially request the death penalty assurance, and that's a routine bit of business. Why that hadn't been done, it's difficult to be sure. It may have been some idea that by not doing it, by having the looming threat of the death penalty, that puts still more pressure on Assange. It's hard to be certain. Why this? But this final assurance request on the argument of discrimination by nationality, if you like, it's simply the last argument standing. The argument's always been there, and just as all the other arguments have been knocked away by the court,
right,
that's the last argument left standing. And again, if you asked me to move away from from what's happening in court and what the actual issue being discussed is, to what's behind that, what's happening behind the scenes, if you like, I think there's a very good argument that the British establishment is fumbling its way towards a situation where it can stop the extradition without making a ruling that fundamentally is hugely mind-blowing in terms of the British state saying the United States was committing war crimes which had been revealed, or the United States was illegally spying and stealing documents from Julian Assange, or the United States was plotting to kidnap and kill Julian Assange. It's quite a big thing for a British court to turn around and say any of those. Was what they've managed to do is find a much softer technicality on which they might be able to stop it. And I think that's, and don't get me wrong, I don't believe that there's any mastermind or committee sitting around plotting this. I just think they're fumbling their way towards the outcome they rather desire, and this is where we've got to.
Alexander, do you share the view that this is a major change, a significant change in what's happening in Assange's case?
I think it is a major change. And can I just say, I agree with much of what Craig says, but I would actually go further. I think this is a more substantive decision than perhaps Craig is suggesting. And I'll explain why. Because, of course, they're saying, yes, we are granting leave to appeal because he might face discrimination in terms of invoking his First Amendment rights his First Amendment defense in the United States. But by saying that, the High Court is saying that he has or ought to have a First Amendment Act defense in the United States. and that if he is sent to the United States and deprived of his right to do that, then he could be also, in effect, be denied his human rights in Britain. Now, that, it seems to me, is actually quite a substantive issue, because it suggests that some people within the court, and I think this is where the point about the stakes, the high stakes involved, that comment comes from, are starting to understand that there is an issue here which relates to the work of the press, of the media, and that what the United States has been doing is in effect trying to restrict the rights of media, of journalists operating outside the United States who are not American citizens and who they say are not therefore eligible for the rights under the First Amendment. So I think this is actually quite an important decision. But I will agree, I will say this, I agree with Craig in this absolutely critical respect, which is that having decided it in that way, having come to that point, having reached that point, it's very difficult logically now to see how the court, the High Court, can refuse the appeal when it is heard. Now, I don't think they wanted to be put in this position. I think they did want, basically, to send Assange to the United States, hoping that all of these issues could be worked out there. And I think that is why they asked for those assurances, because they didn't need to ask for those assurances. They could have simply granted leave to appeal, but they chose not to. They prompted the United States to come up with assurances. And I think they were hoping that the United States would come up with assurances that they could accept and work with, and which they would allow them to allow the extradition to happen. And the big question is, why did the United States not give assurances? Well, Craig is absolutely right. There's case law in the United States, there's policy in the United States, policy decision in the United States, which says that non-American citizens cannot cite the First Amendment in cases like this. But based on what we have seen from the High Court in the past, specifically in this case, they seem to be prepared to accept assurances which appear to cover their points. The point about the assurance the Americans gave in this case is it didn't come anywhere close to doing that. It was almost defiant. It basically sort about it, it used words like seek. It effectively admitted that there was almost certainly he would not be able to rely on the First Amendment protections in the United States. They then went off on a disastrous line of argument, saying that the First Amendment didn't even apply anyway to the kind of things that he had done, which would, of course, only have confirmed the judges that if he is sent to the United States, he's not going to be able to rely on the protection of the First Amendment. And that's why we have the decision that we did. So the question is, why did the United States come up with an assurance that was so completely inadequate to what the High Court was asking for, and why they took the line they did? And I think the short answer is that the United States does want to prosecute people who are not Americans for doing the kind of work, the kind of journalistic work that Julian Assange has used to do and wants to do again, and who are not Americans. And they don't want to give even the smallest indicator that there might be any doubt about that. So because they had to take that very, very hard line on this issue, which is for them a key issue, that is why the High Court made the decision that it did. So in a way, seeking the assurances from the US has smoked them out. It's made it quite clear what their agenda is, which is to police journalists around the world and to prevent them from saying things that the United States and disclosing things that the United States doesn't want them to disclose. So it's had that effect, but it's also landed them in the situation that they now find themselves in Britain, where they're now facing an appeal, where, as I said, on the facts and on the law, it looks like they're going to lose.
Of course, even if the Department of Justice had wanted to give a guarantee that he can use a First Amendment defense, they couldn't, because they're in the executive branch, and that's a decision of the judicial branch. So they're stuck. They could not give that. But even then, Kronberg never said he would. Yeah, sorry.
Yeah, they couldn't give that kind of assurance, but they could have gone. I think they could. I think the High Court was hoping that they would come up with a clearer, stronger assurance than the one they did. Otherwise, why seek an assurance at all? Why not simply grant leave in February, which frankly is what they should have done? If they see that there is a problem here, it's not for them to prompt the United States to provide assurances, to tell the United States of America, how it should conduct its litigation. Instead, they asked the United States to come up with assurances, which suggests to me that if the Americans had come up with something more intelligently worded, and lawyers can come up with very intelligent, very clever wording when asked to do so. If they'd come up with something like that, they'd have probably said, well, look, it looks as if he's not going to be discriminated after all. We can find a way around. Let's send him to America, and the Americans can sort it out. And then, of course, if he's in America and it turns out that he doesn't, he's not able to rely on the First Amendment, well, the British could wash their hands of the whole thing, say, we did our best. We had these assurances from the Americans. It didn't quite add up to what we thought. But there it is. We did what we could. Instead, as I said, the Americans went down a completely different course, a very defiant course. And as I said, they embarked on a line of argument, which, as I think, was completely misconceived, and which I think the judges would have seen as provocative. And I just find it difficult also to understand why the English lawyers, the very, technically competent English lawyers who are representing the United States, who, whatever we may think of them as people, I mean, they know their law and they know their court practice, why they let themselves go down this extraordinary route, because it was obviously counterproductive. And from what I can see, Fitzgerald and Summers saw that, and I think again one has to say they played the game with great skill.
Let me bring in Chris Hedges here. Chris, in the meantime, Julian remains locked up in Belmarsh prison. He's not been charged in the UK with any crimes. Biden gets to do his election campaign without Julian showing up. Your piece about this was a bit sobering. I'd like you to give us your take on whether you're optimistic about what happened on Monday.
I'm not as optimistic as Craig or Alexander. First of all, I think that it was intentional. The lawyers danced around it. The U.S. didn't give that insurance because the Biden administration does not want Assange extradited before the November election. I think that's clear. I think that we have to back away and recognize that this entire process has been illegitimate from the start. The legal anomalies that have been used to go after Julian violate the most basic forms of due process, just the evisceration of attorney-client privilege, the attempting to charge an Australian citizen whose publication is not based in the U.S. under the Espionage Act, et cetera, et cetera. And so this is, I saw what happened as part of that pantomime. The lawyers, I suspect, had to make these, as Alexander points out, fairly hollow arguments because the U.S. didn't give an insurance intentionally. And I think that we have to be clear about the engine behind the extradition. It's not the executive branch. The extradition request was not filed until after the revelations of Vault 7, the hacking tools that the CIA uses to monitor us through our phones and television and cars and everything else, even when we turn it off. And they're furious, and they remain furious. And the CIA is not an organization endowed with the Christian virtue of forgiveness. In fact, you can't get hired if you show that kind of empathy. And they are determined to get Julian, just as they have been determined to go after on much smaller level all sorts of figures, Daniel Hale, Chelsea Manning, Kiriakou, and others, who they see as exposing the secrets of empire, the dirty secrets of empire. So this is clearly driven by the intelligence community. They are determined to get Julian. I think they recognize that that's got to happen after November. I think that there's a strong element of this kind of prolonged intentional torture, the slow motion execution, 7 years in the Ecuadorian embassy, over 5 years now in Belmarsh prison. So, yeah, I mean, as Alexander pointed out, lawyers can do all sorts of stuff. Remember, they gave all sorts of assurances, these diplomatic notes before, which the court accepted, even though many of them were absurd, the most absurd being that he would not be held in Florence, ADX, Colorado, our Supermax prison, pre-trial. No one's held in Florence pre-trial, no one. That he wouldn't be subjected to SAMs, but he can end up in a CMU, there's a controlled management unit, which replicates the special administrative measures of SAMs almost completely. I mean, so, and then of course, if he violated any of the quote unquote rules, all of these measures could be, and the courts accepted that. So I read it as one, let's hope he disintegrates, continues to disintegrate. He's already in precarious psychological and physical health in Belmarsh for perhaps another year, who knows, but we'll get him in the end. I don't see anything in the kind of the way the CIA operates. I, of course, covered the CIA for many years as a foreign correspondent, that leads me to believe they're going to let him walk free for Vault 7.
Craig, you want to respond to that?
I will do. I think obviously there's going to be a tension. Well, there is, I think, a tension in the United States between the interests of the people close to Biden and those who have been engaged in lobbying people around the Justice Department and close to Biden on behalf of Julian. Report that there definitely are very senior officials who understand that it's not helpful in an election year, that the idea of Julian arriving in chains would be unhelpful. And some of those people do see that actually the best course is for Biden to drop it. But then you've got the unremitting massive hostility of the CIA, and Chris is absolutely right in that, and that remains. But then you've got other factors in play, which are the Australian government and its attitude, and what appears to be shifting attitude of public opinion worldwide and in the UK, and what does seem to be something of a shift in the hardline attitudes of the British establishment. So it's certainly possible, and there is an interpretation of what's happening, whereby the whole thing is just. Of course, in the meantime, Julian is still in jail, in a terrible jail where he shouldn't be at all. And there is certainly a possible interpretation that the whole thing is just kicking it into the long grass till after the presidential election, and then it all gets going again. That is not an impossible interpretation. But it isn't my reading at the moment. It really isn't my reading. I think there is a sign here that the situation, I believe, has pushed the judges in the UK beyond the terms point where they are prepared to humiliate themselves in terms of intellectual self-respect. That is my reading of what's happening, which is a more optimistic reading than Chris's, but everything he says is true and could well be right, because we don't really know the exact answer. We're trying to read the signs, and I don't deny any of his signs. There are alternative things you can take from this, and alternative facts you can stress as to which are the most important. My reading remains, I'm happy to say, a little more optimistic than Chris's, and I hope I'm right. But it could well be he is right.
I certainly hope Craig's right too.
Before I go to Chip, Alexander, if you wanted to
Yeah,
respond.
I mean, anybody who is utterly cynical about this process has every good cause to be. I mean, I've discussed this many times. We've discussed this many times. I've said that the procedures, the way this thing has been conducted from the outset has been astonishing. I mean, the very act of seeking assurances from the United States, the court actually prompting the United States to provide assurances, I would say was an unorthodox one, to say it mildly. I mean, courts are not supposed to conduct the litigation of the parties, and the parties are supposed to be able to conduct their own litigation. Assurances were accepted in the other appeal in a most extraordinary way at the back end of a hearing, which is brought on a completely different issue. I mean, obviously, there's lots of reasons to be doubtful and skeptical about this. Having said that, I think the point to make is simply this. At this moment in time, we're involved in a legal process. There has been a positive decision made. I think we have to hold on to that. Now, obviously, just to make one point, the United States can come back and they can give assurances all over again. They can say, well, the assurances we gave before, we've really looked into them. We've actually sought more advice. We've rethought about this. We can actually give you rather stronger assurances. Will you accept them this time? I mean, that's one possibility. But they have made it more difficult to do that now because of that extraordinary line of argument they took in their skeleton arguments and in the hearing itself, which I think make it very difficult for the court at this time to accept any assurances on this question from the United States at all. So I think we are inevitably going to have a substantive hearing. And given the way the law and the facts add up, it will require some extremely, how shall I say, twisted line of reasoning from the judges to refuse this appeal. So I'm not saying they're not going to do that, but I can't myself see how it can happen. And I have to say that, I mean, it could turn out, that this all turns into some kind of Wyszynskian farce. But for the moment, I don't see any reason to think that based on the decision that we've just had.
Let me just throw in a decision.
Yes, go on, Chris.
Yeah.
Every decision is twisted. I mean, they won't even recognize him as a journalist. Every single decision they have made is twisted and deform the most basic rules of journalism and due process. I mean, every decision's twisted.
Oh, no, I understand. Just to come back, I understand that. And as I said, if you look at the past of the case, you can see that. But as I said, we have a decision at the moment, which on its merits makes sense. I think, we've got to work with this and hope that this will continue into the next hearing, because if not, what hope is there? I mean, what point is there any longer in us continuing to fight as we must do? That's basically the point I'm making. And the best way to fight a political case, as I've said many times, which is what this is to fight it using the law and the procedures and taking the arguments that the judges themselves have previously accepted, which are in his favor, and they've now done that, and work with that. I can't see what alternatives there is, and on that basis, something of a victory of a kind was achieved on Monday.
There's some sign of progress towards justice in that in the October 2022 High Court hearing on the U.S. appeal, the judges did not allow Assange's lawyers to challenge those assurances. They just accepted them. Where at least in this case, they were able to challenge the assurances in writing and in that hearing, and that may have contributed to the court's decision. There's a very blunt line from the U.S. From Assange's lawyers, where they say the ability to seek to rely upon the First Amendment means nothing. Any defendant whose counsel can open their mouth can raise and seek to rely upon. So it doesn't say that he can rely on it. He can only ask to rely on it, and that is certainly not an assurance. Chip Gibbons, thank you for waiting there.
One quick thing.
So let me ask you. Yes, Chris?
Never gave an assurance. I mean, we're acting as if we rejected the assurance. The U.S. consciously didn't give it.
Yeah. That's a good point. That's right. And the Assange lawyers were able to point that out, at least this time. Chip, give us first your general views about what happened on Monday. You were also there here in London. And then I want to ask you two questions about about constitutional issues that arose from Monday's.
Sure. So I would say on an optimism to pessimism scale, I'm between Craig Murray and Chris Hedges in terms of my pessimism to optimism. I have to give Craig a lot of credit because I went into Monday's hearing thinking that it would be an adverse ruling to Assange. And I heard Craig outside on the speaker's platform saying he thought the judges would reject the non-assurances, and he was correct and I was wrong. And I was very, very happy to be wrong on Monday. So, it's difficult to parse how optimistic we should be here, because when we go back to the March ruling, much of it is so negative towards Julian Assange. The section about his free expression rights under Article 10 of the European Convention on Human Rights, the parts that are not dealing with the discrimination issue, are extremely chilling. The court claimed preposterously that only 3 of the charges against Julian Assange had any relationship whatsoever to free expression rights. The rest of the charges, all of which dealt with news gathering, whistleblowing, publishing information, journalism, were just ordinary criminal charges, and that there was no free expression interest, and that in the remaining 3 charges, which are the so-called pure publication charges, and that the only offense that is alleged is publishing the information to the internet, that there was no public interest in what was published, which is absolutely preposterous. And in a lot of the free expression analysis in that March opinion that is adverse to Assange, if you read it closely and you read the other things Kronberg said about the First Amendment, not that he has no First Amendment rights because he's a foreign national, or he may not have First Amendment rights because he's a foreign national, the logic mirrors it very, very closely. They advance this legal fiction that what Julian Assange and WikiLeaks did is not journalism, but that they were soliciting other people by mere fact of existing as investigative journalists. They were soliciting other people to illegally obtain information. I believe one of the lawyers for the representing the U.S. Pointed out that Chelsea Manning was not granted First Amendment protections for her actions. And if Julian Assange is complicit in her actions, why then should he be granted First Amendment protections? I 100% think the First Amendment should have protected Chelsea Manning's actions, but there is a distinction between a whistleblower and a journalist legally. So I went into this really, and then of course the absurd part of the ruling that they can no longer raise the fact that the CIA wants to kill him, because if they bring him to the US, the CIA will have no reason to kill him. So I really read March's ruling in the most cynical, pessimistic way possible, that this was a court that was prepared to rubber stamp the persecution of a journalist, rubber stamp the idea that you can be prosecuted for exposing war crimes, rubber stamp some of the excessive, but not the most excessive arguments of the US government. And Gordon Kromberg, in his utterly unnecessary comment in the declaration that the US might argue Assange lacks First Amendment rights as a foreign national, and the UK lawyers absolutely dropping the ball when asked by the judges about the death penalty, just deprived them of the opportunity to do that rubber stamp, and that they would accept any assurances like they have in the past. I mean, people have talked about how the assurances about prison conditions are so filled with holes, he could be placed under SAMs, etc. When they actually describe what the treatment they will give him in Alexander, Virginia, this isn't one of the holes. This is them assuring how well they would treat him. The treatment they describe actually under the UN Nelson Mandela rules for minimum treatment of prisons constitutes torture. So the US gave assurances the last time, basically guaranteeing to torture Julian Assange, and then any protections beyond that had giant holes in it. So I didn't go in optimistic, and I'm not sure how we read a court that has stated there's no free expression, appealable grounds on free expression rights, that you shouldn't be prosecuted for exposing these war crimes, but there is a free expression right, or there is a free expression interest in being able to rely on the First Amendment, which if he relies on the First Amendment the way he relied on Article 10 before these two judges, he would lose the case, right? So it's not, it is really hard to read the situation, but I do think the US is just so arrogant and is so hubristic in the types of arguments that they're making that the court is either unable to rubber stamp or objectively horrified. And I will also point in that we're in a position we were in 2021. I think Craig alluded to this somewhat, that this is a chance for either the Biden administration to walk away or the British courts to kill the extradition in a way that doesn't have the sort of worst possible outcome for the US, right? In 2021, they rejected all of the free expression arguments. They rejected the political offense exception, which 100% should have barred this extradition from day one, and instead went on the prison conditions. So the Biden or Trump could have dropped it without getting a ruling that you can't be prosecuted under the Espionage Act, extradited under the Espionage Act, and it's wrong for the US to prosecute journalists. Once again, the courts are not saying it's wrong what the US is trying to do with the Espionage Act, but they are coming up with a technical legal point that could kill the extradition. So it's a chance to end this horrible persecution while allowing the US to save face. And I have no interest in allowing the DOJ to save face, but I'm just saying that's the political moment we're in. And it's, part of me thinks maybe the judges just can't do what they want to do and rubber stamp this with these terrible statements from the US. And part of me thinks they are maybe perhaps setting up an opportunity to finally resolve this while still allowing the US Espionage Act regime to stay in place internationally and have a chilling effect on journalism that rolled over.
So just two technical questions. On the First Amendment, the application of the First Amendment in his defense would be on every one of the 17 counts under the Espionage Act, not just the 3 that the U.S. said they would be able to abide by. In other words, the publishing ones. See, I didn't even understand that news gathering is also protected under the First Amendment. I'm kind of embarrassed to say that you'd explain that to me, even though I've been in the news business since
You know what else is protected under the First
49
Amendment?
years ago.
You know what else is protected under the First Amendment? Your right to receive information. So at Defending Rights and Dissent, where I'm policy director, we have always made the argument, I wouldn't make this before a judge, I know how it would go before a judge, but in the court of public opinion, where I have a more favorable audience, we always make the argument that the actions against Julian Assange are a violation of every American citizen's First Amendment right to receive information and ideas, because the goal, so there is a right to publish, there is a right to news gathering, and those rights are held by the journalist and the publisher, and then there is a right to receive information and ideas. All of these are protected by the First Amendment, although I would not rely on the third argument in a court because courts are very reluctant to recognize that right. They recognize it on paper, but they don't often recognize it in fact. It came up in, I believe, the 60s or the 70s when Ernest Mandel, a British or Belgian Marxist, was scheduled to speak in the U.S. and the Nixon administration blocked him. And people were like, well, we have a right to hear what he has to say.
Now, at one point in that hearing Monday, James Lewis went off about a half an hour, it seemed. And I confess, as a layman, I was lost. It was a drawn-out, arcane, overly lawyered argument about the difference between citizenship and nationality. And to me, it was incomprehensible as a non-lawyer. Chip, what do you have to say about that? And he also introduced the 14th Amendment of the Constitution into this, where the Assange lawyer said, well, this is a completely new argument. Tell me what he meant by this citizenship nationality argument, and where's the 14th Amendment play in this?
Well, Joe, I wouldn't be too hard on yourself because I am an expert in U.S. constitutional law, and I had no idea what he was talking about either on the 14th Amendment point. On the citizenship between nationality point, I do understand what he's talking about. The 14th Amendment was passed after the Civil War during Reconstruction, and it applies to the states. It did two really important things. It bound parts, but not all of the Bill of Rights, to the states. So before the 14th Amendment, the courts held, First Amendment says Congress shall not abridge your rights. If the, local sheriff or Alabama state legislator abridges your First Amendment rights, that's totally okay. So what the 14th Amendment held is that we have First Amendment rights, we have other rights, Fourth, Fifth, Sixth Amendment rights that are incorporated into the states, and that the states have to follow them. That has nothing to do with what they're arguing. But the other thing it did was states could not deny people equal protection under the law. And there's this very convoluted scheme in constitutional law about different types of classifications. Some classifications are semi-suspect, some are inherently suspect. And one of the classifications, I know I'm making everyone's eyes glaze over, and my eyes are glazing over too, listening to myself, is that is discrimination based on national origin. And what national origin discrimination is in the 14th Amendment context, and I just want to be clear, totally irrelevant to this extradition, completely nonsensical to even bring this up. What national origin discrimination would be like, okay, Bob and Mike are both U.S. citizens. Mike's great-grandfather came from Ireland. Bob's great-grandfather came from Japan. Therefore, I'm forgetting which one is which. Bob has Japanese national origin, and Mike has Irish national origin. You couldn't discriminate between them unless you had a compelling reason and it was narrowly tailored to do so. The idea of national origin discrimination has absolutely nothing to do with the idea in this extradition proceeding of being prejudiced by your nationality. So I believe what the lawyers were trying to argue, and I'm not even sure because they were so muddled, was that, Julian Assange is not being prejudiced because of his nationality, because if there was an Australian national who had U.S. citizenship or a U.S. citizen of Australian national origin, which is a third concept that is different than both nationality and citizenship that they just threw in and muddled together, they would have First Amendment rights. But someone from any nationality who is not a citizen might not have those rights.
I'm sorry I asked you, Chip. I'm sorry, but that gives you a flavor of the nonsense. They just threw stuff against the wall to see what could stick. That's how desperate, right?
There was a point where the lawyer stood up and said he's not being prejudiced because of his nationality, but because as a matter of law, he's a foreigner. And imagine telling a layperson he's not being prejudiced because of his nationality. He's just a foreigner, right? Imagine, it's nonsense. You're giving me horrible flashbacks to 2L year, Joe. With these questions.
Okay, I'm gonna move on to the second part of our show about Netanyahu, but I think Kathy Wogan, you still have a question to ask? Oh, I want to ask Craig before Kathy comes in. Are they going to ask for bail? Assange's lawyers, do you know? Have you heard?
I don't believe so. I've sent them a message saying that they should, but I've done that several times in the past and never succeeded. I mean, they've always taken the view that the judges are just going to say no because of his history of seeking asylum, which was, of course, characterized as bail jumping. And so it will just be refused. And it will give the judges, the prosecution in court, and the media a chance to drag out all kinds of stuff from the past and repeat it again. And that given it won't succeed and will have that negative effect, it's not worth doing.
Right.
I mean, myself, I would, I think the plus side is so big, I would give it a go, given his state of health.
Right.
But it's not, but I've certainly seen nothing that anticipates that they're going to change your mind. And that's the reason why, because of all the negative stuff the prosecution would throw and would give the media a chance to repeat.
All right. Kathy, you have a question here.
Yes. Chip, I take your point about there being a difference between Chelsea Manning and Julian Assange in terms of Chelsea Manning's contract, her oath to the army, and the difference in status between whistleblowers and journalists. But I don't think that's the point. The point, of course, is that Julian Assange is a foreigner. And there was an argument raised by Lewis that he wouldn't have any constitutional protection anyway if he was complicit with Chelsea Manning. Now, my question is actually for Craig, and this is in terms of the acceptance of assurances. Now, we know that foreigners who acted abroad in the United States don't have constitutional protection. It seems to me that the US would have to give an assurance whereby they are going against their own domestic law. Is it proper for the United Kingdom to accept an assurance that goes against a country's own domestic law?
It would be up to the court. I mean, the defense could argue that it should not accept it on those grounds, but I mean, so far, the United States seems to have accepted that because it is against its own law, the executive can't make its own law and it's not going to give the assurance. So I don't think it's going to arise. I don't think we are going to see the assurance. Diplomatic assurances are given all the time in extradition cases. And generally, they come from countries like Jordan or Iraq or Egypt saying we won't torture this man if you send him back, and they're always broken, and the court knows they're going to be broken. I mean, bluntly, it's an extremely cynical maneuver to enable extradition, courts have accepted eye-watering assurances from terrible regimes, and you could write a book on assurances that have been broken from different countries around the world. It's a way of preventing defences from stopping extraditions, because otherwise so many extraditions would become impossible because we extradite people in terrible places. But the Americans do seem to be constrained by their... So I wouldn't put it past the court. If the Americans just gave an assurance, the court doesn't look behind it. The court does not look behind the assurance. And if the Americans gave an assurance, I would be extremely surprised if the court didn't just accept it. But the Americans seem to accept they are constrained by their own law and they can't give this assurance.
Yes, and I have another question for Chip. Chip, it was suggested to me, in fact, it was the ruling of Judge Kavanaugh in the Open Society case in 2020, that if foreigners had the same constitutional protection when they act abroad as residents or citizens, I should say, then it would be impossible to go after terrorists. Now, it has been suggested to me that the origin of this distinction comes from the beginning of the war on terror. Would you be able to enlighten us as to the history of this discrimination? When did it arise in the United States?
Sure. So the Open Society case, it's really worth to stress that ruling is very narrow. It is talking about foreign nationals operating abroad And in the case, Kavanaugh correctly states that the U.S. has always considered foreign nationals abroad not to have consular protections. I believe this issue originally came up during the U.S. invasion of the Philippines, where there was an argument whether the Constitution follows the flag and the U.S. could be held responsible for its actions in the Philippines, because the U.S. Bill of Rights is written in negative language. It's all Congress won't do this, the government won't do that. It isn't like, Americans have this right or people have this right. So there's an argument to be made that the government is always constrained by it, because you can't violate freedom of expression, then you can't violate freedom of expression, not you can't only violate freedom of expression of U.S. citizens. But it's always been held for an extremely long time, well before the War on Terror, that you don't have constitutional claims against the U.S. government if you are a non-U.S. person abroad. And in the Open Society case, this is about receiving funding for groups that are working on malaria and HIV. And what had happened was, I believe it was the Bush administration made all people who received this funding take a public position that they were opposed to the legalization of sex work. And of course, a lot of groups working with people who have HIV don't want to take that position, because the demographic who they're helping would not trust them. And in 2013, I think it was, a group of American NGOs sued the U.S. government, saying you couldn't make Americans take that case. You couldn't make Americans take that position in the context of receiving this U.S. aid. And where that came up a lot was in the anti-BDS laws that were passed. But then about a decade later, the Supreme Court came back and said, while you can't make U.S. NGOs operating abroad take this position, you cannot, foreign NGOs operating abroad don't have that same constitutional right. It's worth pointing out that, yes, if you are a so-called terrorist who's not a U.S. citizen and you're in Yemen or Afghanistan, you don't have constitutional rights the courts are likely to recognize. If the U.S. brings you to this country and puts you on trial, you have all of the constitutional rights that are given to any criminal defendant, which is part of the reason why we like to do renditions to black sites, holding people in Guantanamo, murdering people with drones, as opposed to bringing them to the U.S. to stand trial. So I think it's a real stretch of an argument for Kronberg to say that if Julian Assange is brought to Virginia, he should be treated as a foreign national abroad, because at that point, he's not abroad, he's in Virginia. And he should have all of the procedural rights that our Constitution guarantees any criminal defendant. And if there are limitations placed on criminal prosecutions by the First Amendment, I would argue that those should apply to him.
And not only that, Chip,
yeah.
I just want to interrupt for a moment, because Julian Assange was on U.S. soil when he revealed the collateral murder video. Isn't that correct? At the National Press Club. And under U.S. law, even though something may have been published in a newspaper, it's still classified. It doesn't become declassified because it was in the New York Times. They still classified. So he revealed classified information on U.S. soil. Isn't that an argument that his lawyers could make? That he reserved the rights now?
So collateral murder video was never classified. It sat on a shelf for many years.
Well, that's okay. Did he reveal anything else of that?
No.
Video at the National Press Club?
He's also not charged with collateral murder. He's charged for the rules of engagement that were posted on the collateral murder website, but he's not formally charged with the collateral murder video.
Okay. Can we move on to Benjamin Netanyahu, unless Alexander looks like he wants to say something?
I just wanted to say a very quick thing, which is that the advocacy by Lewis and the others, the thing to understand about it is absolutely terrible advocacy. It was the worst kind of advocacy that you could do in a case like this. Not only does it highlight to the court that the assurance that the court is asking for has not been given, but it makes it much more difficult for the United States to revisit this question, which is arguably what they might want to do. The courts have said, they said in this Assange case before, that they are not going to go behind. In effect, they're not going to go behind assurances. That's what we saw in when the previous set of assurances was given. They're going to accept assurances because assurances are given by the United States. So they're not going to go behind them. So given that was so, if you weren't prepared to provide a complete assurance now, the best tactic, given that your assurance is inadequate, is to say as little as possible and keep your ammunition dry for the next hearing, perhaps planning to give a different kind of assurance later. Instead, they went off on these incredible arguments, which all they will have done is confirm to the judges that the United States cannot give the undertaking that the court is seeking. It was such bad advocacy that it's difficult to understand how it happened. And I do wonder whether maybe Chip has got put the finger on it, which is that it's arrogance and hubris. They thought that they could just, basically bullshit the court, and that they would get through with something. I mean, it was terrible advocacy, of an arrogance and a stupidity that they haven't yet shown up to this point in this case. And I don't know what happened, but whatever it was, whatever the reason, just take away the fact that it made it possible not just for Assange to get a victory, but he's in a stronger position in the forthcoming appeal than he would otherwise have been in.
Speaking of arrogance and hubris, I'd like to bring up the topic of Benjamin Netanyahu. Alexander asked that we discuss this today, and I think that it happened on the exact same day of Julian's hearing is quite extraordinary, because it was an enormous day for news in those two stories. Now, since October 7th, since Israel's response to October 7th, we've seen a tremendous change in how the world is viewing Israel. It was always taboo to criticize, of course, Israel. They were always accused of being an anti-Semite for doing that. And now, within the last 7 months, we have the International Court of Justice putting Israel on trial, essentially, for alleged genocide. And now the prosecutor of the ICC, International Criminal Court, has asked a panel of 3 judges to come up with arrest warrants for Netanyahu, the prime minister, and Yoav Gallant, the defense minister, and 3 Hamas leaders. We will learn, apparently it takes a couple of months before we'll learn whether those arrest warrants come through. But, more than 30,000 people had to die before we got to this point. So the French government apparently has said that they would abide by this decision if he's going to be an arrest warrant is issued. In other words, if Netanyahu showed up in France, they're obliged to arrest him. I don't think the Germans have gone that far at all. They say they respect the independence of the court, but they're not saying. But they certainly didn't react as badly as the United States did, where Biden called it outrageous, and Blinken, the Secretary of State, called it shameful that the ICC would dare issue or ask for the prosecutor arrest warrants for Netanyahu. Of course, Netanyahu himself responded by calling Khan, the prosecutor, one of the great anti-Semites in modern times. I mean, it's just laughable, some of the responses to that. So I'm wondering, let's talk to Alexander first. Could the Americans be worried about being next, or would we be going too far? What is your reaction to the ICC doing this? And what, in terms of our overall theme of this show, about the changing of tide of history here? What have we seen here? There's progress on the Assange case, but this is magnitudes greater, what happened on Monday.
Well, it is very important case. My own view is that the ICC, the prosecutor, didn't want to be here. He didn't want to issue, to make that request for warrants. And if you look at his statement and what he said, first of all, you can see the enormous pressure he's been under, which is very revealing. But also, he's gone for just one issue, which is the starvation issue. He's avoided everything else. He's tried, in effect, to limit it as far as he can. He's not talking about what's going on the West Bank. He's not discussing all of these things. Now, the reason he's done it, in my opinion, is this is not ultimately legal. It's not a legal process that has brought him to this point. It's politics. It is precisely the shift in the world that is happening. The fact that more and more countries, more and more people around the world are outraged by what they're seeing the Israelis do in Gaza and in other places, and are demanding that an institution that calls itself the International Criminal Court has to step forward and actually do something. And if you listen to him very carefully, essentially, that is what he's saying. He said, I have to do this because the reputation, the credibility of my own institution is in effect on the line. So he limits it as far as he can. He only goes after two political leaders, Netanyahu and Gallant. He throws in the Hamas people as well. This is a strange thing to do, I would have said. But, we're not really just going against the Israelis. We're going against the Hamas as well. But the fact is that he's made that request for those warrants. And that is already a tremendous thing. And it's going to change a lot of the way in which not just public opinion, but courts, political figures around the world, I think, look at this. And it's a sign that this decades-long impunity that Israel has had ever since the 1940s is beginning finally and at last to run out. Now, will the United States be next? I would like to think so, but I have to say I can't really imagine that can happen, not in any time soon. But Israel, well, they finally reached a point which they never expected to be in.
When I meant the United States, I didn't refer to Iraq or Vietnam or any numerous. I was talking about their selling of weapons to Israel.
No, I exactly.
Yeah.
I still don't think so. I think that given how nervous the chief prosecutor is, and you need to read his statements and to watch his comments, I don't think he's prepared to take on the United States in that kind of way. And of course, there are fundamental jurisdiction issues with the United States. I don't think it's going to happen anyway. I don't think he's going to take those risks. So I think we should be pleased that he's made this. It's only a request for warrants. Yep. It's not yet a decision to issue those warrants. The pressure on the judges is going to be enormous. But nonetheless, the chief prosecutor of the International Criminal Court has made this request. He's been under tremendous pressure, both directions, but he's had to go ultimately with a global majority because he knows that the credibility of his whole institution and, as he himself said, of the whole web of law is now at risk.
Chris, what was your reaction to this story? You must unmute, unfortunately.
It was unfortunate in that the crimes that Israel has committed in Gaza dwarf by far the atrocities and crimes that were committed by Hamas and other resistance groups on October 7th. And I think, as Alexander pointed out, focusing on the very narrow issue of starvation is easily rectified if humanitarian aid is brought in, then that is abolished. All the other acts of genocide that Israel commits on a daily basis were ignored by the court. We should also recognize or acknowledge that both the U.S. and Israel does not recognize the validity of the court itself. I think there was tremendous international pressure because the court's primary focus, much to the delight of NATO and the U.S., has been Russia and Ukraine. And I think they don't want to jeopardize that case. I don't know that it's going. I think it's significant in terms of further isolating Israel, further cementing into place Israel's status as a pariah state. I would add the United States is largely a pariah state at this point, certainly in international bodies like the UN. So it's significant from that point of view. But I do think his hand was forced, given the scale of the slaughter that's taken place in Gaza. And I do find it rather cynical that he went after that very narrow issue of famine.
Well, they claimed that because Israel wouldn't let his investigators into Gaza, that he couldn't investigate the bombings and the other killings. But that's the excuse they gave. Greg, what do you make of this? Does it change the game a lot? What significant is this?
I think we got used to the idea of complete impunity for Israel. And this does change that game. I should say I'm rather pleased because I was one of the people who was pressing the Palestinians to take the step of acceding to the Rome Statute some 10 years or so ago. And it was precisely on the basis that it would be able to do this. And also we've then seen through, of course, the ICC's own expert working group and decisions on whether it has jurisdiction or not, and that's been decided. So the fact that the United States and the United Kingdom are trying to query that in Germany is rather pathetic, because that's water under the bridge. But it is a game changer. It's going to make it much harder for Netanyahu to travel. He'd be able to go to the United States, but he'd run the risk, for example, of his aircraft being forced down somewhere else, like Edward Snowden's, like the one they thought Edward Snowden was on.
Even Morales, yeah. Even Morales.
Yeah. It's certainly going to make life much more difficult, and it puts the so-called democracies on the spot. The wonderful thing about it is it highlights the fact that the so-called Western liberal democracies have abandoned. We knew some time ago that they actually abandoned the bedrock of liberal Western thought, which had been built up since the Second World War on traditions even older than that, and then had become established in these international institutions. They'd abandoned their belief in that belief system and had gone entirely for a kind of neo-imperialist writer's might system, but they were still hiding behind the facade. Was now at both the ICJ and the ICC, they are now forced to admit that they have abandoned the principles of international law. They're now forced into that position, and I think this is fascinating. I agree with I've got no time whatsoever for Karim Khan. He was appointed precisely because he would do anything he possibly could to avoid doing this sort of thing. And he has been absolutely forced into it. But that also, I might say, if you look at the articles I wrote about why action should be taken under the Genocide Convention, one of the things I say there is getting the ICJ to act under the Genocide Convention is the only way to force the ICC to do something. And I think that's played through as well. The ICC was in a position where either it becomes totally and utterly irrelevant and is condemned in the eyes of nearly all the world for the charade that it is, just to attack the West's enemies, or it had to do that. I really think they had no choice. May I excuse myself now? I do apologise. I'm actually meant to be at a very important meeting in Blackburn today, where we've just cleared a general election campaign, and where I'm launching my candidacy there today. I'm launching the start of campaigning there in the actual election campaign itself, and I've just received notifications, which is what I've been doing on my phone, that all trains south of Scotland are cancelled because of floods. So I now have to work out how on earth I'm going to get there.
Oh my goodness!
I'm going to have to dash off and find a way to get to Blackburn.
Well, I think to launch a campaign for Parliament is a good excuse to leave our webcast. Thank you very much, Craig, for being with us.
Good luck, Craig. Good luck.
Thank you.
Good luck with your campaign, Craig.
Chip also has to leave in about 10 minutes. So if you want to weigh in on this issue of Netanyahu.
Yeah, I'll confess that I have not had time to dig in deeply on the specifics of what the ICC has done. This is a funny story. I was waiting to do a live television broadcast about the Assange hearing when the decision was made, and I had someone talking in my ear, and they were going through all the news of the day, and they said, and Netanyahu's been indicted by the ICC, and I thought for sure I must have been having an audio hallucination because this couldn't happen. But I covered the ICJ hearings for Jack it then. I sat through the arguments. I've been involved in Palestine solidarity activists since 2007. I think that's how I first met you, Chris, was when I was a college student who was doing Palestine. Is that or Occupy? I don't remember which. It's been so long. And I do think, as limited as it sounds like it is from Chris, and as much skepticism as I have of the ICC, I do think this is a historic turning point in terms of Israel can no longer receive the type of impunity that it used to. I mean, Israel has conducted multiple murderous raids or murderous wars in Gaza since 2009. It is involved in deliberate, blatant ethnic cleansing in the West Bank. It is clear the scale of violence in Gaza, where you see people digging up people outside hospitals who have been murdered execution style, has arisen to the level of genocide. And in the past, you've never seen an ICC indictment, even after the raid on the Freedom Flotilla, even after the 2009, even over the crimes in the West Bank. And I agree with Craig. I don't think the ICC wanted to do this. I think they're being pushed to this point. And I think part of what has pushed them to this point is just how terrible it looked, where you had the ICJ hearing this extremely plausible evidence of genocide. I've never been someone to use the phrase genocide lightly. It is, many war crimes, many massacres, many atrocities can be quite horrible, but that doesn't mean they meet the legal definition of genocide. Most don't, and it doesn't make them any less horrible. But the evidence is very clear that Israel is trying to kill the people in Gaza in order to destroy them as the Palestinian people. And the evidence is very clear. And I don't think the ICC could sit and do nothing. I wish they were doing more. I wish they may have done something different. But this is a historic moment where we have both ICC warrants against Netanyahu and the ICJ finding it's plausible. They haven't made a final ruling yet that Israel is committing genocide. You have majority support across the U.S. for a ceasefire. You have people all across the country and world protesting, and the response of governments have been to basically shut down what we have left of freedom of speech. So we're in an incredible moment right now, historically. And it does feel like something has to change, although I know there's been other points in history where people have felt like something had to change and it didn't. So, but I'm a little bit more optimistic about this one.
Right. Thank you, Chip, for that. The question of whether Palestine has the jurisdiction, is their jurisdiction in this case. When Palestine became an observer state in 2012 at the General Assembly, it was after that they were a state. They were considered a state. They are already a state. I had this conversation in email with Alexander before the show, and just this week, or just yesterday, Norway, Ireland, and Spain have declared that they recognize the state of Palestine. And there is a perception that is in the media, mainstream media, that's completely wrong about this, and it's fed by the Israeli and the U.S. government. And that is that it's up to Israel and the United States to determine whether Palestine is a state or not. Because if you listen to the American representative Robert Wood at the UN in the vote that they had some weeks ago at the General Assembly about Palestine becoming a full member, he said there has to be negotiations between Israel and Palestine to determine statehood. And this is completely wrong in my understanding. And I'm going to ask Alexander, who's the lawyer, because it's bilateral states that recognize other states that creates statehood, not a vote at the UN. The UN does not vote for statehood. The UN, Article 4 of the UN Charter says that any peace-loving state can apply for membership of the UN. So you have to be a state first before you can apply. And they are a state. They're an observer state, and the vote was to make them a full member state now. But under the Montevideo Convention, which is still in force, and it's customary international law, from what I understand, it's a bilateral recognition, and there are now more than 140 nations recognize Palestine. And Colombia announced today they're going to put an embassy in Palestine, I guess somewhere in Ramallah. So I want to ask you, Alexander, just because I'm getting a lot of trolls who are coming after me saying that, of course, Palestine's not a state, because they're reading in the New York Times. They're reading that this has to be negotiated between Israel and Palestine. And it's not That's not the way I see it. How do you see that, Alexander?
What creates a state is the decision and will of the people who constitute the state itself. This is a nation, and there's always arguments about what a nation is. But if there's a nation, and that nation defines itself as a state within its territory and its borders, then we're already taking a huge step in saying that there is a state in terms of international law. If other states start to recognize that state, which has been created by those people on their territory, then again, I think the legal position is absolutely clear. Beyond a certain point, the fact that a state exists is incontrovertible. The existence of a state, in other words, is a matter of fact. Now, I don't think anybody looking at the situation of the Palestinian people today would dispute that there is a state there. The fact that large parts of that state are in a condition of occupation does not itself mean that we are not talking about a state. And I think that is widely acknowledged around the world, that Israel doesn't want to acknowledge that because it is in conflict with the very concept of a Palestinian state. It is not something we should support. It is something we should be concerned about, because by denying the existence of the state itself, they are also calling into question the rights of the Palestinian people and whether those people who are there are in fact even a people at all. So I think, Western governments that take this line are on a very, very slippery slope indeed. Now that's, I think, my view. Perhaps not all lawyers would agree with it, but it's certainly my view, and I know an awful lot of lawyers who would.
So it looks as though a tide definitely is turning in the Assange case, in the world's view of Israel, and maybe now also on recognizing that Palestine is a state and has been a state, because Spain, Norway, and Ireland, Western European countries, apparently riling up other Western European countries, this decision, have now come forward to recognize Israel. None of this would have happened if Israel didn't respond the way they have to October 7th. So one could say they're digging their own grave. Chris Hedges, if you have any final words on any of the things we've discussed.
I don't think there's any coming back from this. That doesn't mean that Israel won't be able to perpetuate its apartheid state for some time, but it certainly lost the next generation. I don't think it can peddle the myth of the only democracy in the Middle East and flowers blooming from the desert and all the other stuff that has acted as a kind of subterfuge for this settler colonial project. I don't think that's. I think in that sense, the mythology of Israel has been obliterated. It is now seen for what it is. For those of us, of course, I spent 7 years reporting out of the occupied territories and on a daily basis kept attempting to expose. I think it's now exposed and it's not going back, and that's significant.
Well, Alexander, if you want the final word.
No, I think it is an important. I think it's a key event, actually. I mean, it shows that also control of international law is starting to shift. And this is an important thing because international law, until very recently, has ultimately been very much controlled by the Western powers, the legal communities of the West. They've been the people who've decided how it would work. International criminal law, international humanitarian law. The United States has made a huge issue about international humanitarian law. That they're saying that international humanity, the fact that they interpret international humanitarian law enables them to interpret other parts of international law as well. And now we see, for the first time, an international court actually rebelling against this. It's not happy to do it, doesn't want to do it. Karim Khan doesn't want to be sanctioned by the United States, but they've done it. And I think that is a seminal moment. It's a seminal moment for the Palestinians. It's a seminal moment for the Middle East, for Israel itself, and for the world. And just to quickly add, very quickly about the difference between the ICJ and, of course, the ICC. The ICJ looks at disputes between states. The ICC brings cases against individuals. So for the first time, individual Israeli officials, Netanyahu and Gallant, are facing indictments. And that is always a very uncomfortable situation to be in.
Well, they handed it on a silver platter to the ICC in their statements of intent, of genocidal intent, which were extraordinary, and they keep happening. And then they back it up with actions.
Absolutely. I mean, their rhetoric has been astonishing. And by the way, Karim Khan just very, very briefly squirrels in to his statement the fact that one of the facts that's led to this decision to request these arrest warrants is what he extraordinary language he uses, the statements of the group that is supposed to have carried out all of these things that he's asking for arrest warrants for. So does the group just confine itself to Netanyahu and Gallant, or are we talking about a larger pool of people? And if it's a larger pool of people, why not seek arrest warrants against them also? And if it is just Netanyahu and Gallant, which is absurd, by the way, then why not say so? Why not say the respondents to this request? Why use this very strange word, group? But it's the kind of thing that Karim Khan is hiding behind, because to say again what Chris Hedges and Craig and Chip have all said too, he didn't want to do this. This is not what he wanted to do. And in some ways, that makes what's happened even more significant.
Very good. Thank you, Alexander Mercouris in London and Chris Hedges in Princeton, New Jersey. Chip joined us from Annapolis, Maryland, and Craig Murray was in Edinburgh, Scotland. Kathy Vogan, our producer, and she intervened with some important questions as well. And we thank you all for joining us today, and we'll see you soon on CN Live. Goodbye.
Get out your notebook. There's more.
If you are a consumer of independent news, then the first place you should be going to is Consortium News, and please do try to support them when you can. It doesn't have its articles behind a paywall. It's free for everyone. It's one of the best news sites out there, and it's been in the business of independent journalism and adversarial independent journalism for over 2 decades. I hope that with the public's continuing support of Consortium News, it will continue for a very long time to come. Thank you so much.